everyone, I am Anjana and you're watching me on LawPutra's YouTube channel. We all know what a contract is. It is an agreement by two parties with consent, with consideration and legal obligations. Now I am here to discuss about two types of contracts, that is void contract and voidable contract. In a court of law, for a contract or an agreement to be protected, it needs to be possible. So the basic element of difference between void contract and voidable contract is enforceability. Section 2G of the Indian Contract Act 1872 defines a void contract as a contract which is not enforceable by law, whereas the 2I of Section 2I of Indian Contract Act 1872 defines a voidable agreement as an agreement which is enforceable by law as the choice of one of the parties or both the parties of the contract. Now let's discuss about the differences of void and voidable contract. I'll tell you about a few important differences only. There are a lot of differences, but I'm just telling you about a few and important ones. First one is that in a void contract, there will be no obligations nor no rights to the parties because there is not a contract in a void contract. The void contract cannot give to any legal liability because the transaction is nullity and it is not at all covered by law. Whereas a voidable contract comes at the desire or option of one party. It is the desire of the party either to rescind it or to continue it. It is enforceable at the of that person. A voidable contract remains valid until it is rescinded. A void contract cannot confer any rights, whereas a voidable contract confers enforceable right till it is not essential. A contract becomes void when it ceases to be enforceable. A contract becomes voidable when the consent to the agreement is made through misrepresentation, fraud, undue influence or coercion. A void contract cannot be made valid by the parties to the contract because obviously it doesn't exist. A voidable contract can be made by the party who has the right to rescind it by giving up his right of rescinding the agreement. An example now, let's discuss about some examples of void and voidable. The first example of the void contract is the case law, which is Collins versus Godfrey. In this case law, God received a subpoena to present the evidence in the court. But instead of going to the court himself, Godfrey asked Collins to go on behalf of him him a certain amount of money. But later, Godfrey told Collins that he will not be paying him any money. So Collins decided to sue him by going to the court and saying about his promise which was broken. But the court held that Collins' action was not maintainable as the performance of an existing legal duty is not a proper consideration. Thus, their agreement was considered void on the ground that there was no consideration on the side of the plaintiff. Thus, it was not a contract. Now, let's move on to the example of voidable agreement, which is a case called Bolf Grain Company versus Ross. In this agreement, in this case law, an intoxicated wheat producer under the influence of alcohol entered into a contract, but he did not perform his obligations when he came to know about the rate of price of wheat. So it was a landmark judgment about that where a party is inebriated in the contract, the contract is voidable at the option of the party. To sum up, I would like to say that a void contract may involve an illegal activity, or it may be against public duty, or it may be impossible to perform, or it may involve a party who is not legally competent. A voidable contract may be made out of fraud, misrepresentation, or it may be a mutual mistake of both the parties. To sum up, the provisions surrounding void and voidable contract are very important in the law of contract. It is possible for that provisions to render an agreement unenforceable by law by making it invalid. An agreement may be void if it cannot be enforceable by law by either party due to it being unsatisfying by the standards of a valid contract. Voidable contracts are valid contracts but may be invalidated at the option of one party in the contract, or maybe both the parties. Therefore, these provisions are really important and instrumental to the law of contract worldwide. Thank you and have a nice day.